Welcome back to Criminal Procedure CRJU 201A. Today we're going to be discussing interrogations and confessions. Today's learning objectives include understanding the voluntariness test, understanding the McNabb-Mallory rule, knowing Escobedo v. Illinois, know the right against self-incrimination, understanding Miranda v. Arizona, understanding the relationship between the Miranda decision and the Fifth Amendment, understanding custodial interrogation, knowing the public safety exception, knowing the Miranda warnings, understanding the invocation of the Miranda rights, understanding waiver of the Miranda rights, understanding question first and warn later, knowing waiver following invocation of the Miranda rights, understanding interrogation, and knowing police interrogations and the Sixth Amendment. The practice of police interrogation has long been shaped by the work of Professor Fred Inbau of Northwestern University, who argued that popular culture misleads the public into believing that most crimes are solved through scientific evidence or eyewitness testimony. In reality, he maintained many cases are solved only through confessions. Inbau illustrated this point with the hypothetical example of a homicide in which no physical evidence or witnesses link a suspect to the crime. After extensive questioning, a financially desperate relative eventually confesses. From this, Inbau drew three conclusions. Many crimes can be solved only through admissions of guilt. Suspects often confess only after sustained questioning. An effective interrogation may involve techniques that appear manipulative in ordinary interactions. Justice Antonin Scalia echoed this view in Minnick v. Mississippi, observing that even a foolish but voluntary confession is preferable to leaving offenders undetected. Confessions play a central role in the criminal justice system. They assist in crime detection when other evidence is lacking, promote accountability by encouraging offenders to accept responsibility, and increase efficiency by facilitating convictions of the guilty and, at times, exoneration of the innocent without prolonged trials. Jurors tend to place significant weight on confessions, often viewing them as compelling evidence of guilt. At the same time, confessions raise serious concerns. Police may be tempted to use physical or psychological coercion, particularly during incommunicado interrogations, conducted without counsel or judicial oversight. Heavy reliance on pretrial confessions can also undermine the adversarial principle that guilt should be established beyond a reasonable doubt in open court. Most troubling is the risk of false confessions, which can lead to wrongful convictions. Vulnerable suspects, such as those who are young, uneducated, or lacking confidence, may be especially susceptible to manipulation, while wealthier or better informed individuals are more likely to resist questioning and obtain legal counsel. These concerns about reliability and fairness continue to shape constitutional protections governing police interrogation. Before we delve further into false confessions, I would be doing you a disservice if we did not discuss in a bit more detail the Central Park Five. In 1989, a brutal assault and rape in Central Park shocked the nation and led to one of the most infamous wrongful conviction cases in American history. Five teenagers, Antron McCray, Kevin Richardson, Yusef Salaam, Raymond Santana, and Corey Wise, were arrested in connection with the attack. They were charged with crimes including rape, assault, robbery, and attempted murder. After lengthy interrogations, each gave statements implicating himself and, in varying ways, the others. Some of these statements were videotaped and later presented to juries. At trial in 1990, the prosecution relied heavily on the defendants' confessions, despite inconsistencies among the accounts and the absence of DNA evidence linking them to the crime. Four of the teenagers, McCray, Richardson, Salaam, and Santana, were tried together and convicted. Corey Wise, who was 16 and therefore tried as an adult, was tried separately and also convicted. The young men were sentenced to terms ranging from approximately 5 to 15 years. Wise ultimately served approximately 12 to 13 years in prisons, while the others served between 6 and 7 years before being released. In 2002, a convicted serial offender, Matias Reyes, confessed to acting alone in the attack. His confession was supported by DNA evidence that matched biological material that was collected from the scene of the crime. evidence that had never matched any of the 5 teenagers. As a result, the convictions of McCrae, Richardson, Salam, Santana, and Wise were vacated later that year. The case stands as a powerful example of the dangers of false confessions, particularly when juveniles are subjected to prolonged interrogation. In 2014, the 5 men reached a $41 million settlement with New York City. The Central Park Five case continues to be cited in discussions of interrogation practices, juvenile vulnerability, racial bias, and the need for procedural safeguards to prevent wrongful convictions. Nowadays, Kevin Richardson lives in New Jersey with his wife and 2 daughters. He's an active criminal justice reform speaker. Antron McCrae resides in Georgia with his wife and 6 children. He is focused on his family but shares his story to educate others. Raymond Santana lives in Georgia and in 2018 launched his own clothing company, Park Madison NYC, which is a combined entrepreneurship and advocacy initiative. Corey Wise is the only member of the group who lives in New York City today. He is a public speaker and criminal justice advocate. He has also founded a nonprofit which supports the wrongfully convicted. Yusef Salam lives in Georgia with his wife and 10 children. He is a public speaker, poet, and activist. False confessions present one of the most troubling challenges in the criminal justice system. Even in situations where police do not use overt physical force, individuals isolated in interrogation rooms have admitted to crimes they did not commit. One of the most striking instances was that of the Central Park Five, which we just discussed. Several factors contributed to the false confessions in that case, including intense public pressure on police to solve the crime, confirmation bias once suspects were identified, the youth and limited intellectual capacity of some defendants, misleading statements about evidence, and interrogations lasting more than 28 hours. Research by Professors Steve Drizin and Richard Leo identified 125 proven false confessions between 1971 and 2002. Although many were uncovered before trial, dozens of defendants received lengthy prison sentences, and some were sentenced to death. Even if rare relative to the total number of confessions, wrongful convictions based on false admissions undermine confidence in the justice system. Psychologists generally identify 3 types of false confessions. Voluntary false confessors come forward without pressure, sometimes seeking attention or acting out of guilt or mental impairment. Compliant false confessors admit guilt to escape a stressful interrogation or to gain a perceived benefit, such as leniency. Internalized false confessors actually come to believe they committed the crime after repeated suggestions, confrontation with alleged evidence, or failed polygraph tests. Other cases reinforce these concerns. Eddie Joe Lloyd falsely confessed to a 1984 rape and murder in Michigan after police persuaded him that doing so would help catch the real offender. He was exonerated by DNA evidence in 2002 after serving 17 years. Similarly, the Norfolk Four, Navy sailors who confessed to a 1997 rape and murder, were later pardoned after serious doubts emerged about the reliability of their confessions. The American legal tradition holds that it is better for guilty individuals to go free than for an innocent person to be wrongfully convicted. False confessions directly challenge that principle. As a result, courts have struggled to strike a balance between recognizing the importance of confessions in solving crimes and ensuring procedures that guard against coercion, unreliability, and miscarriages of justice. When we talk about constitutional limits on police interrogation, we are really talking about 3 different constitutional provisions that operate in distinct but sometimes overlapping ways. The 14th Amendment's Due Process Clause, the 5th Amendment's Self-Incrimination Clause, and the 6th Amendment's Right to Counsel. Let's begin with the 14th Amendment. In the 1930s, the Supreme Court began using the Due Process Clause to evaluate whether confessions obtained by state officers were voluntary. The clause provides that no state shall deprive any person of life, liberty, or property without due process of law. The court recognized that interrogation pressures, especially when combined with isolation, intimidation, or deception, could overbear a suspect's will. An involuntary confession violates due process because it undermines the individual's freedom to choose whether to speak and may ultimately result in imprisonment based on an unreliable statement. Justice Arthur Goldberg captured this concern in Escobedo v. Illinois, warning that a system dependent on confessions is more prone to abuse and less reliable than one grounded in independent evidence. Even today, courts continue to apply a voluntariness test under the Due Process Clause, examining the totality of the circumstances to determine whether a confession was the product of free choice or coercion. The Fifth Amendment takes a different approach. It reflects the deeply rooted principle that in our accusatorial system, the government bears the burden of proving beyond a reasonable doubt that someone is guilty, and a defendant cannot be compelled to be a witness against himself. This stands in contrast to older inquisitorial practices, such as those of the English Star Chamber, which used compulsion and even torture to extract confessions. The framers of the Constitution were determined to reject that model. The privilege against self-incrimination was therefore enshrined in the Fifth Amendment and later interpreted in Miranda v. Arizona. In Miranda, the court concluded that custodial interrogation is inherently coercive and that procedural safeguards are necessary to protect the privilege. As a result, before custodial interrogation, police must inform suspects of their rights to remain silent, that anything they say can and will be used against them, and that they have the right to an attorney. Unlike the flexible due process voluntariness test, Miranda establishes a bright line procedural rules designed to prevent compulsion before it occurs. The Sixth Amendment right to counsel comes into play at yet another stage. Once formal judicial proceedings have been initiated through indictment, arraignment, or similar formal charges, the government has committed itself to prosecution. At that point, the accused has a constitutional right to counsel during critical stages of the process, including interrogation. In Brewer v. Williams, the court emphasized that denying counsel after formal charges may effectively seal a defendant's fate and reduce the trial to a mere formality. The Sixth Amendment therefore prevents the government from deliberately eliciting incriminating statements in the absence of counsel once adversarial proceedings have begun. Let's keep in mind the differences among these three doctrines. Due process focuses on voluntariness and fairness under the totality of the circumstances. The Fifth Amendment, through Miranda, imposes prophylactic warnings to safeguard against compelled self-incrimination in custodial interrogation. The Sixth Amendment protects the accused after the initiation of formal proceedings and ensures the presence of counsel at critical stages. Finally, remember the distinction among admissions, confessions, and statements. An admission is acknowledgement of a fact that tends to establish guilt, such as being present at the scene. A confession is a full acknowledgement of criminal responsibility. A statement may include either inculpatory or exculpatory remarks, though the terms are sometimes used loosely. The legal consequences attached to each can differ significantly. The due process voluntariness test is an approach that dominated Supreme Court confession law from 1936 to 1966. During that 30-year period, the court invalidated more than 30 state and local confessions under the 14th Amendment because they were deemed involuntary. The roots of the voluntariness doctrine stretch back to English common law. In the 18th century, English judges held that confessions were inadmissible if obtained through threats, physical force, promises not to prosecute, or assurances of leniency. The concern was reliability. A confession extracted by fear or hope of reward might not be true. Because courts had no reliable way to verify the truth of a confession, they adopted a shorthand rule: exclude statements that were not voluntary. This principle was articulated in Rex v. Warwickshire. The United States Supreme Court adopted this approach in Haupt v. Utah, holding that coerced confessions were inadmissible in federal courts as a matter of evidentiary law. The court reasoned that when police tactics are sufficiently coercive, the assumption that an innocent person would not falsely incriminate himself ceases. A few years later, in Braham v. United States, the court linked the voluntariness principle directly to the Fifth Amendment privilege against self-incrimination. though at that time the ruling applied only to the federal government. In practice, however, there was often a gap between the law in the books and the law in action. The 1931 Wickersham Commission reported widespread use of the third degree, a euphemism for brutal physical and psychological tactics designed to extract confessions. One of the most disturbing examples is found in Beecher v. Alabama and its follow-up decision in 1972. Johnny Daniel Beecher was shot while fleeing police. As he lay wounded, officers threatened to kill him unless he confessed to raping and murdering a white woman. A rifle was fired near his head, and he confessed. Later, hospitalized, in severe pain, and under heavy doses of morphine, he signed additional statements after being pressured to cooperate. The Supreme Court overturned his conviction, describing the confession as the product of gross coercion. When Alabama retried him and relied on yet another statement allegedly made while he was medicated, the court again reversed in Beecher v. Alabama, holding that no conviction tainted by such coercion could stand under the Due Process Clause. These rulings built on the court's landmark condemnation of torture in Brown v. Mississippi, where defendants had been whipped until they confessed. Brown marked the beginning of the modern era of confession law, firmly establishing that convictions based on physically coerced confessions violate due process. The voluntariness test, therefore, focuses on the totality of the circumstances. Courts ask whether, considering all the facts, threats, promises, physical condition, duration of questioning, age, education, and mental capacity, the defendant's will was overborne. If so, the confession is inadmissible. While later doctrines, especially Miranda, would introduce more structured safeguards, the due process voluntariness test remains an important constitutional backstop against fundamentally unfair police conduct. Next, we're going to focus on how the Supreme Court applied the due process voluntariness test to state courts, beginning with its landmark decision in Brown v. Mississippi. In Brown, 3 black men, Arthur Ellington, Ed Brown, and Henry Shields, were convicted of murder in Mississippi, based solely on confessions extracted through brutal physical torture. Ellington was hanged from a tree, repeatedly whipped, and threatened until he signed a confession dictated by the sheriff. Brown and Shields were stripped and beaten with leather straps fitted with metal buckles. Chief Justice Charles Evans Hughes wrote that the record read more like pages torn from some medieval account than proceedings in a modern constitutional system. The Supreme Court unanimously reversed the convictions. It held that confessions obtained through physical coercion violate the Due Process Clause of the 14th Amendment. The court emphasized that convictions based on such methods offend fundamental principles of liberty and justice. In language that still resonates, the court declared that the rack and torture chamber may not be substituted for the witness stand. The decision sent a clear message. The government must prove guilt in court, and it may not secure convictions by forcing suspects to condemn themselves. The court soon made clear that due process protects against psychological as well as physical coercion. In Ashcraft v. Tennessee, the defendant confessed after 36 hours of continuous incommunicado interrogation by rotating teams of officers. Although there was no physical violence, the court held that the relentless questioning overwhelmed his ability to exercise free will. The opinion famously noted that modern psychological techniques could rival the efficiency of a rack and the thumb screw. Similarly, in Chambers v. Florida, the court overturned convictions of young black defendants who had endured prolonged questioning under intimidating circumstances. The court warned that permitting convictions based on such confessions would reduce due process to a meaningless symbol. By the time of Blackburn v. Alabama, the court explained that the voluntariness test protects a complex of values. Reliability is one goal. Coerced confessions are often false. But the doctrine also safeguards individual dignity, preserves the accusatorial nature of our system, and restrains abusive government power. Taken together, these cases demonstrate that the Due Process Clause serves as a constitutional floor. When police tactics, whether physical brutality or psychological pressure, overbear a suspect's will, the remedy is exclusion. The cost to the government for violating due process is that the confession cannot be used in its case in chief. Voluntariness doctrine developed, the Supreme Court made clear that its purpose extended beyond screening out unreliable confessions. It was also concerned with fundamental fairness and the integrity of the criminal justice system. In Lisenbaugh v. California, Justice Owen Roberts explained that due process is violated not only when a confession is false, but when the methods used to obtain it offend basic standards of justice. If it would be unconstitutional to use threats, promises, or torture in the courtroom to force a defendant to testify, then a case can stand no better. When the same methods are used in the interrogation room and the resulting confession is introduced at trial. Such conduct, the court emphasized, undermines public confidence in the rule of law. The court also articulated what is sometimes called the police methods rationale, the idea that law enforcement must obey the law while enforcing it. In Spano v. New York, the court stressed the deep-rooted feeling that illegal police practices endanger life and liberty just as surely as criminal conduct does. This principle was powerfully expressed earlier in Watts v. Indiana. There, Robert Watts was interrogated for 5 consecutive evenings, deprived of adequate sleep and food, and not promptly brought before a judge as required by state law. The court held that the Due Process Clause bars police procedures that violate the basic notions of our accusatorial system, and warned that brutal or fundamentally unfair methods of law enforcement are ultimately self-defeating. A further strand of the voluntariness doctrine focuses on whether a confession is truly the product of a rational intellect and free will. In Townsend v. Sane, 19-year-old Charles Townsend, a heroin addict, was given a combination of drugs, including one later revealed to have, quote, truth serum properties, in police custody. Shortly after the injection, he confessed. The Supreme Court held that a confession produced by a drug that impairs a suspect's capacity for reasonable and rational choice cannot be considered voluntary. When police questioning results in a statement that is not the product of a free intellect, the confession is inadmissible under the Due Process Clause. Taken together, these cases show that the voluntariness test protects a constellation of values: reliability, fairness, restraint on abusive police practices, and respect for individual autonomy. Due process demands not simply accurate outcomes, but lawful and fundamentally just methods in the pursuit of those outcomes. The Supreme Court has identified several interrelated values underlying the voluntariness test, beginning with trustworthiness. Confessions obtained through physical or psychological coercion are inherently suspect because a defendant may speak simply just to stop the abuse. In Payne v. Arkansas, a 19-year-old black defendant was held incommunicado for 3 days and confessed only after the sheriff threatened to turn him over to a white mob. The court held that the confession was coerced and did not constitute an expression of free choice. The risk of false confession in such circumstances is simply too great to permit its use at trial. The court has also emphasized fundamental fairness. The use of an involuntary confession compromises the integrity of the courtroom itself. In White v. Texas, Bob White, an illiterate black farmhand, was illegally detained, moved between locations, and interrogated over several days before signing a confession. The Supreme Court ruled that due process forbids condemning an accused, particularly to death, through such abusive and unlawful practices. A conviction, secured in this manner cannot be reconciled with basic principles of justice. A related concern is the prohibition of offensive police methods. In Lynham v. Illinois, officers told the defendant that her children would be taken away and that she would lose state financial aid if she did not cooperate. The court observed that an isolated and inexperienced suspect would have little reason to doubt the officer's ability to carry out such threats. The resulting confession was deemed involuntary because it was extracted through fear rather than free choice. Finally, due process requires that a confession be the product of free will and rational choice. In Blackburn v. Alabama, a mentally incompetent defendant was interrogated for 8 or 9 hours in a room filled with police officers and later found legally insane. The court concluded that the likelihood his confession was the product of rational intellect and free will was remote, and admitting it into evidence constituted a flagrant abuse of due process. The voluntariness test, therefore, rests on the principle that an involuntary confession must be excluded regardless of whether it is true. Due process is concerned not only with accurate outcomes, but with the fairness, legality, and humanity of the methods used to obtain them. The Supreme Court has consistently held that to be admissible, a confession must be made freely, voluntarily, and without compulsion or improper inducement. A statement violates due process when government officials employ physical or psychological coercion, and that coercion overcomes the defendant's will to resist. The central question is whether the suspect's will was overborne. Courts answer that question by examining the totality of the circumstances surrounding the confession, as explained in Haynes v. Washington. No single factor is dispositive. Instead, judges evaluate all relevant conditions, and the prosecution bears the burden of proving voluntariness by a preponderance of the evidence, as established in Lego v. Twomey. Among the factors courts consider are the presence of physical abuse or threats, including intimidation by officers or even hostile crowds, psychological pressure, such as promises of leniency, threats of harsher treatment, or deceptive tactics, the length, timing, and location of interrogation, as well as the number of officers involved, whether the suspect was denied access to counsel, family, or friends, and the defendant's age, education, intelligence, and emotional or mental condition. Courts also look to procedural regularity, including whether police complied with required safeguards such as Miranda warnings. Finally, judges may consider whether officers were acting out of urgent necessity to solve a crime, or instead were building a case against a suspect they already believed to be guilty. The Supreme Court's decision in Spano v. New York illustrates this totality of the circumstances approach. There, the court concluded that the defendant's will was overborne by official pressure, fatigue, and falsely aroused sympathy. Spano was questioned for 8 hours overnight by numerous officers, and police enlisted a childhood friend to appeal to his emotions. His repeated requests to consult with his attorney were ignored. He was young, inexperienced with the justice system, and had limited education and psychological vulnerabilities. Police also delayed bringing him before a judge and were seeking to secure a conviction rather than identify an unknown perpetrator. Taken together, these factors rendered the confession involuntary. Despite its protective aims, the due process voluntariness test has drawn criticisms. It provides no bright-line rules to guide police conduct, leaving officers uncertain about what interrogation tactics are permissible. In many cases, the only evidence about what occurred in the interrogation room comes from conflicting testimony by the defendant and the police, making fact-finding difficult. And finally, the flexible, case-by-case nature of the test has generated substantial litigation and appellate review, increasing the workload of state and federal courts. These concerns ultimately contributed to the court's later effort to craft clearer safeguards in Miranda, though the voluntariness test remains an enduring constitutional backstop. The due process voluntariness test remains an independent safeguard. Even if Miranda warnings are given, a confession that is involuntary under the 14th Amendment is inadmissible for any purpose. In Mincy v. Arizona, the court held that statements obtained from a hospitalized, barely conscious suspect in severe pain, whose requests for counsel were ignored, were involuntary because his will was overborne. In Arizona v. Fulminante, a confession to a paid informant was deemed coerced, where the informant offered protection from violent inmates in exchange for the truth. The court found that fear of physical harm rendered the confession involuntary under the totality of the circumstances. These cases show that due process still requires courts to ask whether official pressure overcame a suspect's free will. In Colorado v. Connolly, however, the court held that police coercion is required for a due process violation, even if a defendant's mental illness raises concerns about reliability. In Colorado v. Connolly, the Supreme Court addressed whether a confession prompted by severe mental illness, but not by police misconduct, violates the Due Process Clause. Francis Connolly approached a Denver police officer and spontaneously confessed to a murder. He was advised multiple times of his Miranda rights and stated he understood them. Officers observed nothing unusual about his behavior. The next day, however, Connolly told a public defender that voices had commanded him to confess. Psychiatric testimony established that he suffered from chronic schizophrenia and was experiencing command hallucinations at the time of his confession. Although his illness impaired his volitional capacity, doctors testified that he understood his rights cognitively. The court asked whether or not a confession violates due process when it is the product of mental illness, even when there is no police conduct that coerced the confession. Chief Justice Rehnquist, writing for the court, emphasized that prior voluntariness cases, beginning with Brown v. Mississippi, focused on police overreach. The Due Process Clause is aimed at preventing abusive state action. Without coercive police activity causally related to the confession, there is no constitutional violation. The court rejected the argument that a defendant's mental condition alone can render a confession involuntary for due process purposes. Concerns about reliability, the court explained, are matters for evidentiary rules, not constitutional doctrine. Therefore, the court's holding was this: coercive police activity is a necessary predicate to a finding that a confession is involuntary under the 14th Amendment. Because Connolly's confession was not the product of police coercion, its admission did not violate due process. The McNabb-Mallory rule emerged in response to widespread criticism that the due process voluntariness test gave police too little concrete guidance. Officers were left to guess how long they could question a suspect, whether counsel must be provided, or what tactics crossed the constitutional line. Defendants, in turn, often had to litigate voluntariness issues on appeal. In McNabb v. United States, the Supreme Court attempted to create a clearer rule for federal cases. The McNabb brothers were arrested, held for 2 days, and intensively questioned without being brought before a magistrate as required by federal statute. Relying on this supervisory authority over federal courts, the court reversed their convictions, holding that confessions obtained during an unlawful delay in presentment were inadmissible. Justice Frankfurter emphasized that courts could not become accomplices in willful disobedience of congressional policy requiring prompt judicial oversight. The court reaffirmed this principle in Mallory v. United States, grounding its decision in Rule 5A of the Federal Rules of Criminal Procedure, which requires that an arrested person be taken without unnecessary delay before a magistrate. Mallory's confession, obtained after nearly 8 hours of questioning and before any judicial presentment, was excluded. The court made clear that police may not arrest first, interrogate extensively, and only later determine whether probable cause exists. Unlike the due process test, which focused on coercion under the totality of the circumstances, the McNabb-Mallory rule concentrated specifically on delay between arrest and initial appearance. Critics argued that it excluded even voluntary confessions solely because of delay. In response, Congress enacted 18 U.S.C. Section 3501 as part of the Omnibus Crime Control and Safe Streets Act of 1968. The statute provides that a voluntary confession is not inadmissible solely because of delay if made within 6 hours of arrest, with flexibility for reasonable transportation delays. Today, McNabb-Mallory is largely of historical importance. Federal courts treat unnecessary delay as one factor in assessing voluntariness, and the rule does not apply to the states. As clarified in United States v. Alvarez-Sanchez, 1994, Section 3501 is statutory rather than constitutional. Most state courts simply consider delay as part of the broader totality of the circumstances analysis. In Escobedo v. Illinois, the Supreme Court took a major step toward regulating police interrogations by extending the Sixth Amendment right to counsel to suspects during pretrial questioning by state authorities. Before Escobedo, the court had hinted, especially in dissenting opinions, that access to a lawyer during interrogation was critical to fairness. In cases like Crooker v. California and Cecina v. Legay, the court rejected claims that denying counsel automatically violated due process, even when suspects specifically requested their attorneys. The majority feared that requiring access to counsel would effectively halt police questioning. However, several justices dissented, arguing that without counsel, the protections of trial were undermined in the interrogation room. The turning point began with Messiah v. United States in 1964, where the court held that once a defendant has been indicted, the government may not deliberately elicit incriminating statements in the absence of counsel. That decision laid the groundwork for Escobedo. Danny Escobedo was arrested for murder, interrogated for hours, and repeatedly denied access to his attorney, even though his lawyer was physically present at the police station requesting to see him. During questioning, Escobedo made incriminating statements after police confronted him with an alleged accomplice's accusation. The Illinois courts upheld the confession as voluntary. The United States Supreme Court reversed. Justice Arthur Goldberg held that when the investigation shifts from general inquiry to focusing on a particular suspect in custody who requests counsel, the Sixth Amendment requires that the suspect be permitted to consult with a lawyer and be informed of the right to remain silent. Denying Escobedo access to counsel rendered his statements inadmissible. Goldberg acknowledged that providing counsel at this stage would likely impede interrogations, since competent attorneys would advise clients not to speak. Nevertheless, he emphasized that the Constitution favors protection of the accused over reliance on confessions. A system dependent on confessions, he warned, is more prone to abuse and less reliable than one grounded in independent investigation. Although Escobedo relied on the Sixth Amendment, its deeper purpose was to protect the privilege against self-incrimination. Just 2 years later, in Miranda v. Arizona, the court shifted the analysis to the Fifth Amendment and created the now familiar warning requirements. In hindsight, Escobedo is best understood as the bridge between the due process voluntariness cases and the comprehensive Fifth Amendment framework established in Miranda. The Fifth Amendment provides that no person shall be compelled in any criminal case to be a witness against himself. In Malloy v. Hogan, the Supreme Court held that this privilege applies not only to the federal government, but also to the states through the 14th Amendment. As Justice Brennan explained, the government must establish guilt through evidence independently and freely secured, and may not coerce a defendant into proving the case against himself. The privilege reflects several core values. First is the cruel trilemma. Without the privilege, a person would be forced to choose among self-accusation, perjury, or contempt. Second is the fear of coercion. History shows that compelled confessions invite abuse. Third, the privilege reinforces the adversarial system, where the state bears the burden of proof and the accused need not establish their innocence. Finally, it protects personal privacy by limiting forced disclosures to the government. Not all information is protected. The privilege applies only when there is a real and substantial risk of incrimination, when the answer could help establish guilt or provide a link in the chain of evidence. In Heibel v. 6th Judicial District Court of Nevada, the court held that requiring a suspect to disclose his name during a valid stop did not violate the Fifth Amendment, because giving one's name is generally not incriminating. The privilege is also violated only when compelled statements are used against a person in a criminal case. In Chavez v. Martinez, a suspect questioned while in severe pain could not recover under the self-incrimination clause because his statements were never introduced in a criminal proceeding. The clause protects against being made a witness against oneself at trial. Compulsion is key. In Hoffman v. United States, the court allowed a grand jury witness to refuse to answer questions that might incriminate him. By contrast, in South Dakota v. Neville, offering a DUI suspect the choice between a blood alcohol test or having their refusal noted in court was not considered unconstitutional compulsion. Finally, the privilege applies only to testimonial or communicative evidence. In Doe v. United States, the court explained that the government may not compel a person to disclose the contents of his mind, facts, beliefs, or admissions connecting him to a crime. However, the privilege does not protect non-testimonial physical evidence such as fingerprints, voice exemplars, handwriting samples, blood draws, lineups, or photographs. The line between testimonial and physical evidence is not always clear. In Pennsylvania v. Munez, the court held that a suspect's slurred speech during routine booking questions was admissible because it reflected physical impairment rather than the content of his words. However, when Munez was asked the date, of his sixth birthday, his inability to answer was deemed testimonial. That question forced him to reveal the contents of his mind, and any answer would have suggested his intoxication. Thus, the Fifth Amendment barred its use. The privilege against self-incrimination, therefore, is rooted in history, fairness, and distrust of compelled confessions. Yet, its application often turns on careful distinctions between compulsion and choice, incriminating and neutral information, and testimonial versus physical evidence. In Schmerber v. California, the Supreme Court considered whether the compelled extraction of a blood sample from a DUI suspect violated the Fifth Amendment privilege against self-incrimination. After drinking at a tavern and bowling alley, Schmerber was involved in a car accident and taken to the local hospital. While receiving treatment, he was arrested for driving under the influence. At the direction of a police officer and over Schmerber's objection, made on advice of counsel, a physician drew a blood sample. The chemical analysis revealed a blood alcohol level indicating intoxication, and the results were admitted at trial. Schmerber argued that the forced blood draw violated his Fifth Amendment privilege, his Sixth Amendment right to counsel, and his Fourth Amendment protection against unreasonable searches and seizures, and due process. The court, in an opinion by Justice Brennan, held that the Fifth Amendment privilege protects against compelled testimonial or communicative evidence, not against the compelled production of physical evidence. Although Schmerber was compelled to submit to the blood draw, he was not compelled to testify or communicate any knowledge. Relying on earlier precedent, such as Holt v. United States, the court emphasized the distinction between compelling a person to disclose the contents of his mind and compelling him to provide a real or physical piece of evidence. Because the blood tests involved no testimonial compulsion and depended solely on chemical analysis, its admission did not violate the privilege against self-incrimination. The court therefore affirmed the conviction, concluding that the Fifth Amendment does not bar the state from requiring a suspect to submit to a blood test, even over objection, when the evidence obtained is physical rather than testimonial in nature. In dissent, Justice Black argued that compelling a person to provide blood so that it can be used to convict him is functionally equivalent to compelling testimony, and warned that the majority's narrow reading of the Fifth Amendment weakened constitutional protections. In Miranda v. Arizona, the Supreme Court held that statements obtained during custodial interrogation are inadmissible unless police first provide specific procedural safeguards to protect the Fifth Amendment privilege against self-incrimination. The court reasoned that custodial interrogation is inherently coercive because suspects are isolated, cut off from support systems, and subjected to psychological strategies designed to overcome their will. The court identified several coercive pressures common in police interrogation. Suspects are questioned in unfamiliar police-dominated environments and separated from friends, family, and counsel. Officers may use psychological tactics such as expressing uncertainty in the suspect's guilt, minimizing the seriousness of the offense, conducting prolonged questioning, or employing the Mutt and Jeff strategy, where one officer asks aggressively and another appears sympathetic to gain trust. A real good cop, bad cop routine. Police manuals at the time even described deceptive practices such as false lineups or fictitious witnesses to induce confessions. The court concluded that these pressures could overwhelm a suspect's free choice. To counteract these coercive conditions, the court required that suspects be given 3 essential warnings before custodial interrogation. They have the right to remain silent. Anything they say can be used against them in court. They have the right to an attorney, and if they cannot afford one, one will be appointed to them. These warnings are required to ensure that any waiver of rights is knowing, intelligent, and voluntary. Without them, a confession is presumed compelled and therefore inadmissible. The case itself arose from the conviction of Ernesto Miranda, who confessed to kidnapping and raping an 18-year-old woman after less than 2 hours of interrogation. He had not been advised of his right to remain silent or his right to counsel. The Supreme Court reversed his conviction, holding that procedural safeguards were necessary to protect the Fifth Amendment privilege in the inherently coercive setting of custodial interrogation. The facts were this. Ernesto Miranda was arrested at his home on March 13, 1963, for kidnapping and rape, taken to a Phoenix police station, and interrogated for 2 hours without being informed of his right to an attorney. During the interrogation, Miranda signed a written confession, which was admitted at trial over the objection of his defense counsel. He was convicted and sentenced to 20 to 30 years imprisonment, and the Arizona Supreme Court affirmed the conviction, emphasizing that Miranda did not specifically request counsel. The issue is whether statements obtained from a defendant during custodial interrogation without being informed of the right to remain silent or the right to counsel are admissible in courts under the Fifth and Sixth Amendments. The Supreme Court explained that custodial interrogation occurs in a police-dominated incommunicado environment, which exerts inherently coercive pressures on individuals that may overwhelm their ability to exercise the right against self-incrimination. These pressures include isolation from friends, family, legal counsel, continuous questioning, exploitation of their guilt or insecurity, and use of psychological manipulation or deception. The court reaffirmed Escobedo and emphasized that without procedural safeguards, confessions cannot be presumed voluntary. The court held that individuals in custody must be informed of their right to remain silent, that statements made can be used against them in court, and that they have the right to consult with a lawyer and have the lawyer present during interrogation. If the individual cannot afford counsel, one must be provided. Interrogation must cease if the individual invokes these rights, and any waiver of these rights must be knowing, intelligent, and voluntary. The prosecution may not use statements obtained in violation of these safeguards. Justices Clark, White, Harlan, and Stewart argued that the majority unnecessarily created new law, that the rule would impede law enforcement, slow investigations, reduce the number of confessions, and increase trials, and that the traditional due process protections under the Fifth and 14th Amendments were sufficient to protect suspects without the rigid procedural requirements imposed by the court in the majority opinion. Ultimately, these Miranda warnings set a clear procedural framework to protect the Fifth Amendment privilege against self-incrimination during custodial interrogation, balancing individual rights with law enforcement interests while requiring voluntary confessions. Saul Kasson and Gisli Gudjonsson are prominent psychologists who studied police interrogations and found that many suspects waive their Miranda rights because they do not fully understand them, often due to youth, low intelligence, or education, or inexperience with the criminal justice system. Police are trained to isolate suspects in small rooms, make them uncomfortable, align with them by justifying or excusing the crime, minimize the seriousness of the offense, display certainty of the suspect's guilt, interrupt denials, and encourage confessions, both oral and written. These tactics exploit psychological pressures that may overbear a suspect's will, particularly if the suspect believes the police already have evidence, such as fingerprints or blood linking them to the crime. In Miller v. Fenton, Frank Miller, a 32-year-old with some high school education and prior prison experience, was interrogated for 53 minutes after waiving his Miranda rights. Detective Charles Boyce falsely told Miller the victim was alive and later dead, sympathized with him, promised psychological help, and encouraged him to confess. The two-judge majority held that Miller's confession was voluntary because he was a mature, experienced adult with no mental or physical illness, and the interrogation lasted less than an hour close to home. The dissent argued that the promises and deception used by Boyce were coercive and should render the confession inadmissible. Modern courts recognize that certain interrogation tactics, including misrepresenting evidence, promises of leniency, or using stereotypes, can constitute coercion and make confessions involuntary. For example, Hawaii courts have excluded confessions obtained by falsely reporting failed lie detector tests or using gender based stereotyping. And Illinois and Oregon now prohibit misrepresenting evidence or offering unauthorized leniency to juveniles during interrogation. These protections reflect growing awareness of the psychological pressures inherent in custodial questioning and the need to ensure that confessions are truly voluntary. The decision in Miranda v. Arizona supplemented the due process voluntariness test by requiring police to provide suspects subjected to custodial interrogation with warnings of their Fifth Amendment right against self-incrimination. The ruling sparked criticism, and in 1968, Congress passed the Omnibus Crime Control and Safe Streets Act, which directed federal judges to apply the voluntariness test and listed factors to determine whether a confession was voluntary. In Dickerson v. United States, Chief Justice Rehnquist, a longtime critic of Miranda, held that Miranda is a constitutional decision required by the Fifth Amendment because custodial interrogation is inherently coercive and therefore Congress could not override Miranda by relying solely on the voluntariness test. Rehnquist emphasized that Miranda has become embedded in routine police practice to the point where the warnings have become part of our national culture. Your book is a little bit out of date, and in the book it states that in Vega v. Taco, the Supreme Court was set to decide whether Miranda constitutes a constitutional right or simply protects a constitutional right, specifically whether a failure to provide the warnings can support a Section 1983 claim for damages. Since the book was published, the Supreme Court determined that the answer is no. A failure to provide warnings under Miranda cannot by itself support a Section 1983 claim for damages. The central elements of Miranda include custodial interrogation, the public safety exception, the three-part warning, invocation of Miranda rights, interrogation, and the waiver of and right to counsel. While the Supreme Court has affirmed the constitutional status of Miranda, its requirements are constantly adjusted to balance the protection of suspects with society's interest in obtaining confessions, raising questions about whether Miranda adequately protects defendants or unduly handcuffs law enforcement, and whether its complexity can be consistently applied by police, lawyers, and judges. Miranda warnings are triggered when an individual is in custody and subjected to interrogation, which Miranda defines as questioning initiated by law enforcement after a person has been taken into custody or otherwise deprived of their freedom of action in any significant way. In Beckwith v. United States, the Supreme Court clarified that simply being the focus of an investigation does not require the reading of Miranda rights, as IRS agents interviewed Alvin Beckwith in a private home for 3 hours in a friendly and relaxed manner, and the court held that the inherently coercive pressures described in Miranda were absent. Custodial interrogation does not include general questioning at a crime scene, voluntary confessions at a police station, or calls made to offer information. But it does apply when an individual is under police control and likely subjected to incommunicado interrogation in an isolated, unfamiliar environment. The Supreme Court recognized the challenge of identifying situations short of formal arrest that create pressures functionally equivalent to custodial arrests, and held that the Miranda warnings are required when such a coercive environment exists. To resolve this, the court adopted an objective test for custodial interrogation, as articulated in Stansbury v. California, which requires judges to evaluate the totality of the circumstances and consider whether a reasonable person would believe they are subject to a formal arrest or its functional equivalent. Factors relevant to this determination include the number of police officers present, whether the individual is informed they are free to leave, the length and intensity of questioning, the use of physical restraint, the location and privacy of the stop, whether the surroundings are familiar or unfamiliar, and whether the stop appears likely to result in brief questioning or a formal custodial arrest. No single factor is dispositive, and custody is evaluated by whether a reasonable person would feel free to leave under the circumstances. Custodial interrogation arises when an individual is questioned while in custody or deprived of their freedom in a significant way, and courts have applied this concept to different contexts. In Orozco v. Texas, the Supreme Court held that 4 police officers entering the defendant's bedroom at 4 a.m. to question him about a shooting constituted custodial interrogation. In contrast, in Minnesota v. Murphy, a probationer who voluntarily met with his probation officer and admitted to a rape and murder was not considered to be in custody, as he was familiar with his surroundings, was not physically restrained, and could have left at any time. And the potential probation consequences did not create pressures comparable to a criminal suspect under police control. In Oregon v. Mathiasen, a parolee voluntarily appeared at a police station, was informed he was not under arrest, and confessed after being falsely told that his fingerprints were found at a crime scene. The court found no custodial interrogation because he voluntarily came and left after the interview. In prison contexts, the court in Illinois v. Perkins held that an inmate questioned by an undercover officer about an uncharged crime was not in custody, as the suspect spoke freely to someone he believed was a fellow inmate, and the coercive elements underlying Miranda were absent. In Howes v. Fields, the court clarified that interrogating an inmate removed from the general population about events outside prison is not automatically custodial. The totality of the circumstances must be considered, and a reasonable person would have felt free to leave, especially when the inmate was informed he could return to his cell, was not threatened or restrained, and was questioned in a well-lit room with occasional access to food and water. In traffic stop cases such as Berkemer v. McCarty, a driver stopped for weaving lanes who admitted to drinking and drug use was not in custody until he was formally arrested, because traffic stops are brief, public, and generally non-coercive. In Yarborough v. Alvarado, an 18-year-old voluntarily brought to a police station by his parents and questioned about a crime was not in custody, as he was not threatened and could leave at the end of the interview. The court applied an objective standard without considering age or inexperience, though the dissent argued that age was relevant. Next, we'll discuss JDB v. North Carolina. JDB v. North Carolina, the Supreme Court considered whether a child's age is relevant in the Miranda custody analysis, holding that children are more likely than adults to feel compelled to submit to police questioning, and therefore age must be considered when determining whether a reasonable person would feel free to leave. The petitioner, JDB, a 13-year-old middle school student, was removed from his classroom by a uniformed officer and questioned for 30 to 45 minutes in a closed conference room without being given Miranda warnings or the opportunity to contact his guardian. And after being confronted with evidence and warned of possible juvenile detention, he confessed to certain thefts. The court emphasized that custodial interrogation exerts inherently compelling pressures that are particularly acute for juveniles, and that the objective custody analysis must account for circumstances that would affect a reasonable child's perception of freedom to leave while still remaining an objective test, and remanded the case for the state courts to reconsider whether JDB was in custody taking his age into account. The dissent, led by Justice Alito, argued that including age undermines Miranda's clear one-size-fits-all reasonable person standard, complicates police and judicial application, and could extend to other individual characteristics such as intelligence, education, or cultural background, thereby eroding the clarity and predictability of the custody analysis. In New York v. Quarles, the Supreme Court recognized a public safety exception to Miranda, holding that police may ask questions reasonably prompted by an immediate concern for the safety of the public or officers without first reading Miranda warnings, provided that the questions are directed at public safety rather than guilt or innocence and the statements are not coerced. The exception requires that the threat be immediate, that the need to protect public safety be reasonable, and that police do not overbear the suspect's will. And while the court left the scope of the public safety broadly defined, lower courts have applied it cautiously. In United States v. Reyes, where a narcotics dealer's admission of a gun and drugs was admitted because the officer's question was directed at immediate safety. In United States v. Newton, where a parolee's statement regarding a firearm in his apartment was properly admitted under the exception, given the officer's knowledge of a credible threat to his mother and stepfather. The federal government has argued that interrogations of suspected terrorists may also fall under the public safety exception to question individuals about imminent threats without issuing Miranda warnings. The warnings inform suspects of their Fifth Amendment rights and require police to advise individuals of the right to remain silent, that the statements they make may be used against them in a court of law, and the right to an attorney, whether retained or appointed. These warnings must be conveyed in clear and unequivocal terms, but need not follow the exact wording of the Miranda decision, as demonstrated in California v. Prysock, where warnings were given to a juvenile in slightly different language but were held to be sufficient. In Duckworth v. Egan, where additional information regarding Indiana's procedure for appointing counsel did not render the warnings inadequate, they were held constitutional. The court has consistently held that the warnings, when considered in their totality, must be reasonably designed to convey the essential information. This was further affirmed in Florida v. Powell, where the warnings informed the suspect he could consult a lawyer before and during the interrogation. And the court clarified that police are not required to provide information beyond the three-part warnings of Miranda. Although debates remain regarding whether additional information about attorney availability is necessary, it appears that some states require it while others do not. In Moran v. Burbine, the Supreme Court addressed whether a pre-arraignment confession must be suppressed if the police failed to inform the suspect of an attorney's efforts to reach him. Brian Burbine was arrested in connection with a burglary and later questioned about a murder. Although Burbine was informed of his Miranda rights and signed a written waiver on multiple occasions, he was unaware that his sister had contacted an attorney to represent him. The police did not inform Burbine of the attorney's call, nor did they mislead him. He voluntarily waived his rights and made incriminating statements. The court held that Miranda's purpose is to protect against the coercion inherent in custodial interrogation, and the police's failure to notify Burbine of the attorney's call did not undermine the voluntariness of his waiver. Expanding Miranda to require notification of an attorney's attempts to contact the suspect was deemed unnecessary and would unduly burden law enforcement. The court concluded that Burbine's statements were admissible because he knowingly, intelligently, and voluntarily waived his rights. In his dissent, Justice Stevens, Brennan, and Marshall argued that withholding knowledge of the attorney's communication compromised Burbine's right to counsel, and that the court's decision favored law enforcement efficiency over the protection of his constitutional rights. After receiving Miranda warnings, a suspect may invoke the right to an attorney or the right to remain silent, but such invocation must be clear and unambiguous. In Davis v. United States, Robert Davis initially waived his rights, but later said he maybe should talk to a lawyer. The Supreme Court held that ambiguous statements do not constitute a clear invocation, and police are not required to clarify a suspect's intent. In Bergquist v. Tompkins, the court ruled that Tompkins' prolonged silence did not invoke his right to remain silent because he never clearly expressed his desire. And the court emphasized that requiring officers to guess the suspect's intentions would impose an unreasonable burden. In Fair v. Michael C., the court clarified that juveniles must specifically request a lawyer, and that requests to speak with probation officers or others do not satisfy Miranda protections. However, Justice Souter, in a concurrence in Davis, noted that vulnerable populations, such as the poor, uneducated, or minority defendants, may struggle to assert themselves during interrogation, suggesting that clarification of ambiguous statements could better protect their Fifth Amendment rights. Courts have also recognized that officers must avoid influencing a suspect when attempting to clarify intent, as illustrated in Hart v. AG, where a police officer's comments discouraged a suspect from requesting counsel. Overall, the law requires unambiguous invocation of Miranda rights. Ambiguity allows police to continue their questioning without violating the Fifth Amendment. Suspects may waive their Miranda rights to silence or to counsel, but the waiver must be voluntary, knowing, and intelligent. A voluntary waiver is a free and deliberate choice, not the product of coercion, intimidation, or deception. A knowing and intelligent waiver requires that the suspect understand both the nature of the rights being abandoned and the consequences of the decision. Courts evaluate the totality of the circumstances, including the suspect's age, education, intelligence, mental state, experience with the criminal justice system, and behavior during interrogation, as well as the conditions and length of questioning and the techniques used by law enforcement. In Moran v. Burbine, the Supreme Court clarified this three-step inquiry, emphasizing that the prosecution bears the burden of showing by preponderance of the evidence that the waiver was valid. Coercion or threats, such as those involving physical violence or overbearing tactics, can invalidate a waiver. Misrepresentations of evidence generally do not invalidate a waiver if the suspect retains independent judgment. Courts also require that suspects actually understand their rights. A mere reading of the Miranda warnings is insufficient if comprehension is doubtful. Waivers may be express, where the suspect explicitly states a desire to speak without counsel, or implied, where the suspect engages in conduct indicating a waiver despite declining to sign a form. In Burgess v. Tompkins, the Supreme Court held that an uncoerced statement following a full understanding of the rights constitutes an implicit waiver, confirming that a waiver need not be formal or written. Overall, the law recognizes that a waiver may be explicit or inferred, but it must always be voluntary, knowing, and intelligent under the circumstances. Elstad v. Oregon, the police initially conducted a brief, unwarned interrogation of Michael Elstad at his home, obtaining a voluntary incriminating statement. They then formally arrested him, read him his Miranda rights at the police station, and obtained a detailed confession. The Supreme Court ruled that the first statement was inadmissible because it was given without Miranda warnings. However, the court held that the second, warned confession was admissible. A voluntary response to unwarned, non-coercive questioning does not automatically prevent a suspect from validly waiving their rights and confessing after receiving proper warnings. The court emphasized that Miranda warnings cure the taint of an earlier voluntary but unwarned statement, and that informing the suspect that the first statement was inadmissible was neither practicable nor constitutionally required. Justices Brennan and Marshall dissented, arguing that the court was diminishing constitutional protections. Following Elstad, some police departments began a two-step interrogation strategy, questioning suspects first without warnings, then again with their Miranda warnings. The Supreme Court addressed this in Missouri v. Seibert. Patrice Seibert was subjected to a deliberate strategy where she was first interrogated for 30 to 40 minutes without Miranda warnings and confessed, then given a brief break before being formally warned and questioned again by the same officer who confronted her with her prior statements. The court concluded that, unlike Elstad, the Seibert interrogation was designed to undermine a Miranda right. In these circumstances, a reasonable person would likely not understand that they had a real choice to remain silent or request an attorney, rendering the second confession potentially inadmissible. The key distinction is that Elstad involved an inadvertent, brief, unwarned statement corrected by subsequent warnings, while Seibert involved a deliberate police strategy to elicit a confession before Miranda warnings, undermining the suspect's ability to make an informed choice. Once a suspect invokes their Miranda rights, the police are generally prohibited from continuing interrogation, but the rules differ depending on whether the suspect invokes their right to silence or their right to counsel. When a suspect asserts the right to silence, the Supreme Court in Michigan v. Mosley established the scrupulously honored test. In that case, Richard Mosley invoked his right to remain silent during questioning about a robbery, and the police immediately ceased interrogation. 2 hours later, after being read his Miranda rights again, Mosley waived them and confessed to an unrelated homicide. The court held that the waiver was valid because the police had scrupulously, honored Mosley's initial assertion of silence. They ceased questioning him, provided a meaningful break, re-administered Miranda warnings, and focused the second interrogation on a different crime in time, nature, and place. Courts have emphasized that continuing questioning in a coercive manner, as in United States v. Tyler, violates this rule even if warnings are repeated. In contrast, when a suspect invokes the right to counsel, the Supreme Court established the initiation test in Edwards v. Arizona. Once a suspect requests an attorney, police may not reinitiate questioning until counsel is present, unless the suspect voluntarily initiates further communication. This protection extends to interrogations about unrelated offenses, as clarified in Arizona v. Roberson, because a suspect who requests counsel is considered particularly vulnerable to coercion. Exceptions have been recognized, such as in Maryland v. Schatzer, where the court allowed police to approach a suspect after a 14-day break from custody, reasoning that the suspect had time to consult with lawyers, family, and friends, and that any decision to waive rights at that point would be the result of informed voluntary choice. In Minnick v. Mississippi, the court emphasized that even after meeting with a lawyer, a suspect may not be interrogated without counsel present unless the suspect initiates the communication. The initiation concept was further clarified in Oregon v. Bradshaw, in which the court held that a suspect's question to a police officer, "Well, what is going to happen to me now?" after previously requesting counsel, constituted initiation and a waiver of the right to a lawyer. The court reasoned that although the question was somewhat ambiguous, it indicated a willingness to engage in general discussion about the investigation, rather than merely addressing routine custodial matters. In practice, the law makes it easier for police to obtain a waiver after a suspect invokes the right to silence than after a suspect requests counsel, reflecting the court's concern that these requests for counsel require special protections against coercion. In sum, a suspect's invocation of Miranda rights requires clear and unambiguous assertion. A waiver of the right to silence is valid if scrupulously honored, and a waiver of the right to counsel is valid only if the suspect initiates communication with the police. Interrogation amounts to either express questioning or its functional equivalent. In Rhode Island v. Innes, the Supreme Court addressed the scope of Miranda protections and clarified the meaning of interrogation. On January 12, 1975, John Mulvaney, a Providence taxicab driver, disappeared and was later found murdered. 5 days later, the Providence police arrested the respondent, who had been identified by a robbery victim, John Aubin, as having previously robbed him. At the time of arrest, the respondent was advised of his Miranda rights multiple times and expressed a desire to speak with an attorney. He was then placed in a police transport vehicle with 3 officers and instructed not to be questioned or coerced. While en route to the central station, 2 officers engaged in a conversation about the dangers posed by a missing shotgun, specifically the potential risk to handicapped children nearby. The respondent overheard this conversation and spontaneously offered to show the officers where the weapon was located. The police returned to the scene of the arrest, and after being reminded of his Miranda rights, the respondent led them to the shotgun. At trial, this evidence was admitted, and the respondent was convicted. The central legal issue is whether the respondent had been interrogated in violation of his Miranda rights after invoking the right to counsel. The court clarified that interrogation under Miranda encompasses not only the express questioning, but also its functional equivalent. Any words or actions by police other than routine custodial procedures that they should know are reasonably likely to elicit an incriminating response. This definition focuses primarily on the perceptions of the suspect rather than the subjective intent of the police, recognizing that Miranda safeguards are designed to protect suspects from coercive practices in custody. Applying this standard, the court concluded that the respondent was not interrogated. There was no express questioning, and the conversation between officers about the shotgun's potential danger did not constitute the functional equivalent of questioning, because the officers could not have reasonably known it would elicit an incriminating response. The court emphasized that isolated offhand remarks, even overheard by a suspect, do not amount to interrogation unless they are reasonably likely to produce self-incrimination. The decision generated dissenting opinions. Justice Marshall, joined by Justice Brennan, argued that the officer's appeal to the suspect's conscience emphasized the risk to a handicapped child. was a classic interrogation technique and should have been considered reasonably likely to elicit a confession. Justice White also dissented, contending that the court's test incentivized police to circumvent the Miranda protections by employing psychological pressure without directly questioning the suspect, thereby undermining the fundamental purpose of Miranda. Ultimately, Innis established a two-pronged definition of interrogation under Miranda: express questioning and its functional equivalent, with an emphasis on what the police should reasonably know might provoke self-incrimination, rather than the police's subjective intent. This case remains central to understanding how courts evaluate subtle coercion and psychological influence in custodial settings. Interrogations have become an increasingly important tool in safeguarding the rights of criminal suspects and ensuring the reliability of confessions. Questions about what occurred during police interrogations often devolve into a swearing contest at trial, with police testifying that they respected the defendant's rights and defendants claiming coercion, manipulation, or trickery. Many legal scholars advocate the recording of interrogations to provide an accurate record and to protect against psychologically and physically coercive practices. Several states require the taping of at least some serious felony interrogations, either through judicial decisions or legislation. For example, Alaska, Indiana, Iowa, Massachusetts, Minnesota, New Hampshire, and New Jersey require recordings, while other jurisdictions, including California, New York, Texas, and the District of Columbia, have enacted legislation mandating recordings for serious offenses. Approximately 1,000 local jurisdictions have voluntarily implemented recording policies, with many limiting recordings to violent crimes. Most states allow either audio or audiovisual recordings, and in 2004, the American Bar Association formally endorsed the practice. Countries such as Australia, Canada, and England also require the recording of confessions. In Commonwealth versus D. Giambattista, the Massachusetts Supreme Judicial Court emphasized the importance of recording interrogations. The court held that when a complete audio tape is not available, the defendant is entitled, upon request, to a jury instruction advising them to weigh the evidence of the alleged confession with great caution and care. The court noted that the failure to record the interrogation forced the judiciary to reconstruct events years after they occurred, and that taping serves both the prosecution and the defense. Recordings provide a reliable means for courts to assess voluntariness, deter coercive police practices, and inspire public confidence in law enforcement. The court also reasoned that informing jurors about the absence of a recording is fair because the prosecution bears the burden of proof and has chosen not to preserve the interrogation in a more reliable form. Critics of recordings cite several concerns. Suspects may be less willing to make statements if they know their words are permanently recorded, and the costs associated with recording equipment and storage may be significant. Others argue that recording alone cannot prevent abuse, as police could still coerce a suspect and later manipulate the recording to appear calm and compliant. Nonetheless, in 2014, the FBI announced that it would record all interrogations, reflecting a growing trend toward transparency and accountability in custodial questioning. The debate continues over whether recordings should be mandatory, balancing concerns about voluntariness, fairness, and law enforcement practicality. The Sixth Amendment guarantees the right to a speedy and public trial before an impartial jury, the ability to obtain witnesses, confront accusers, and have the assistance of counsel for one's defense. The right to an attorney is essential, as individuals without legal expertise may be unable to meaningfully contest their guilt at trial. Over time, the United States Supreme Court has extended the Sixth Amendment right to counsel beyond the trial itself, providing protection during post-indictment interrogations. This right supplements the Fifth Amendment Miranda protections and the due process voluntariness standard, automatically attaching once formal criminal proceedings begin, such as by indictment, information, arraignment, or preliminary hearing. At this point, a defendant transitions from a mere suspect to an accused, and the Sixth Amendment ensures that the determination of guilt or innocence occurs in a courtroom, not through police manipulation or coercion. The foundational case for the Sixth Amendment right to counsel during interrogation is Messiah v. United States. Winston Messiah was indicted for federal narcotics violations, made incriminating statements that were deliberately elicited by government agents without his attorney present. The Supreme Court held that this violated his Sixth Amendment rights, emphasizing that post-indictment questioning without counsel undermines the defendant's ability to challenge evidence and confront witnesses in court. 2 years later, Escobedo v. Illinois relied on the Sixth Amendment to protect defendants during post-indictment police questioning, though the Fifth Amendment protections later used in Miranda v. Arizona overshadowed these rulings for several years. The Sixth Amendment was again applied in Brewer v. Williams, where Robert Williams, represented by counsel, was transported by police and confessed after being subjected to a religiously framed appeal intended to elicit a confession. The court concluded that this deliberate attempt to elicit incriminating statements violated Williams' Sixth Amendment rights. This case reinforced that the right to counsel applies at or after the initiation of judicial proceedings, whether by indictment, arraignment, or similar formal actions. Later cases clarified that defendants must be informed of their Sixth Amendment rights during post-indictment questioning, and that Miranda warnings are sufficient to provide notice of these rights. The Sixth Amendment also protects defendants from interrogation by government informants. In United States v. Henry, the FBI instructed an informant to elicit incriminating statements from a defendant facing trial, which the court held violated Henry's Sixth Amendment rights. In contrast, Coleman v. Wilson ruled that the Sixth Amendment is not violated when an informant passively listens to unsolicited, incriminating statements, emphasizing that the violation occurs only when the government deliberately seeks to elicit information without counsel present. The Sixth Amendment right to counsel is offense-specific, as clarified in McNeil v. Wisconsin and Texas v. Cobb, meaning it applies only to the specific criminal charges for which formal proceedings have begun. Finally, the Supreme Court has recognized that defendants may waive their Sixth Amendment right to counsel, provided the waiver is knowing, voluntary, and intelligent. Montejo v. Louisiana clarified that police may initiate contact with a defendant after the right to counsel has attached, but the defendant retains the ability to voluntarily waive that right. In essence, the Sixth Amendment ensures that post-indictment interrogations respect a defendant's legal representation and protects the integrity of the judicial process by prohibiting police from circumventing the court system to obtain confessions outside the presence of counsel. Confessions play a crucial role in the investigation and detection of crime, but their use is carefully regulated to protect constitutional rights. The procedural safeguards governing confessions are grounded in the Due Process Clause of the 14th Amendment, the Fifth Amendment right against self-incrimination, and the Sixth Amendment right to counsel. Together, these constitutional protections ensure that confessions are the product of fair and lawful practices. To be admissible, a confession must be voluntary, reflecting a free and informed choice rather than a result of psychological or physical coercion. It must also arise from consistent and fair procedures that safeguard the defendant's rights, ensuring the reliability of the confession as an accurate account of the facts. Most importantly, confessions should not supplant the judicial process. A defendant's guilt or innocence must be determined through an adversarial trial rather than through extrajudicial police-orchestrated questioning. These standards collectively aim to preserve both the integrity of the justice system and the constitutional protections afforded to criminal defendants. I'll see you in Chapter 9.